versus Roderick, case number 25-03140. Present in the virtual courtroom, we have both parties as well as their respective attorneys. We are here today on the defendant, Mr. Roderick's motion for a temporary order. I have read both the motion and the response, so the attorneys don't need to go through all of it in excruciating detail. Mr. Quinn.
Yes, thank you, Your Honor. So reading the response, it looks like there's at least one agreement with temporary joint legal custody. I saw that in the response. We attached to our motion as Exhibit M the rights and responsibilities for a joint legal custodian that I think there is an agreement on. I don't know if I got that unequivocally.
That's correct, Your Honor.
Okay, good. Thank you.
And then the next that I didn't really see addressed in the response was our proposal, which is attached as Exhibit N to our motion about the inherent rights of the minor child. I can't imagine there would be an objection to that, but.
Ms. Slate?
Going through the 88 pages, Your Honor, just 1 second.
Sure.
A long one.
It is a long one.
All right. I don't know why we have to.
All right, guys, the courtroom tension starts early. Judge calls in case number to 503140 Roderick vs. Roderick. Both parties are present, attorneys locked in, ready for a storm. The defense wants a temporary custody order, but the judge quickly reminds them no long speeches, just facts. Mr. Quinn steps up confidently, saying both sides agree on joint legal custody. Everyone nods, but that's just the calm before the chaos. The judge's tone is calm, but make no mistake, this is about to get personal and heated.
Parse it out into separate orders. Couldn't we just include that as the temporary order today, Your Honor?
That's the ask. It's
Okay.
just the language that we included. I don't know.
I think he's just confirming that there's no objection to what is proposed on that.
Okay, yeah, the Exhibit M and N, that language could be included, yes.
Good. So 2 down, handful to go still. So as the court indicated, I'm not going to regurgitate what we've put in our response. I know it's long. As a practitioner, and I know the court has presided over these number of years, these motions for temporary order are hard because it's right at the inception of the case, and we need to give the court as much evidence in detail as we can to support our request and show that they're reasonable and appropriate. And I think we did that. Our first ask is with respect to the party's daughter. We're requesting temporary joint joint physical custody and parenting time as detailed in the motion, specifically every Wednesday overnight and alternate weekends, Friday until Sunday. As detailed in the motion, historically, Mr. Roderick has been actively involved with the party's daughter. We listed a number of activities that they share together, and they have a strong bond between them.
Mr. Quinn continues, his voice steady but firm. He wants the court to accept the proposed joint physical custody. He argues that the father, Mr. Roderick, has always been a hands-on dad, deeply involved in his daughter's life. He lists activities, time spent, and their strong bond until the separation. Since then, he says, the mother has limited his time to mere hours a week. The courtroom shifts. You can feel the tension rise. Quinn is pushing hard. This isn't just a request, it's a plea for fatherhood itself.
Unfortunately, since the parties physically separated with Mr. Roderick moving out, he's been unable to get any real meaningful parenting time with their daughter, apart from a few hours a week, which the plaintiff allows. Now, our response to that is there's no reason to drastically limit his time with their daughter to that extent. That's extreme. He's been historically actively involved. He's had considerable time with her, unsupervised for extended periods. And as I know this court is familiar with the statute on parenting time, the parenting time has to be granted in a frequency, duration, and type to promote a strong relationship between the parent and the child. A few hours a week does not. Now, reviewing the response, I note that doesn't appear to be verified at all and appears to include a number of general conclusory allegations that, well, he's abusive, well, he has an alcohol problem. They provide really no details with respect to that, no specific examples. The only evidence or document they attach to support these claims is a police report that I trust the court's reviewed that is.
All right, guys, now Quinn starts tearing into the other side's claims. He calls the mother's accusations unverified, vague, and baseless. He mocks the single police report they attached, calling it totally uneventful and over a year old. He's attacking credibility, painting the father as responsible, sober, and victimized. He says there's no evidence of alcohol problems or abuse, just talk. The courtroom energy sharpens. You can almost hear the gasps. The defense is building momentum, and for a moment, it feels like he's winning the room.
For lack of a better term, totally uneventful, and from over a year ago. Now, they claim in the response that he can only go a couple hours without having a drink. Again, we think that's totally baseless. I want to point out, and we noted in our motion, that Mr. Roderick started a new job not too long ago. And in connection with that job, he underwent a alcohol and drug screen, which he passed. And they were looking at him particularly because he is at times going to be driving a company vehicle and can't have any issues with alcohol or drugs. Passed that test. There's no concerns. He doesn't have a history of a DUI. He doesn't have any alcohol treatment or anything like that. Then there's these allegations of abuse. I want to point out there's been no criminal charges ever against him, no arrests, just because she's called the police maybe a few times to get a report doesn't necessarily translate to him being this terrible monster. And I would like to reference the text messages we attached to our motion. They show that many times the plaintiff is aggressor in their interactions. She claimed
Quinn doesn't stop there. He lays out how Mr. Roderick passed drug and alcohol screenings for his new job, drives company vehicles, and has zero history of DUI or substance abuse. His tone turns aggressive, accusing the plaintiff of twisting facts and weaponizing emotions. Then he pulls out the text messages, the mother allegedly being the aggressor. She claims they're out of context. He says, but where's her proof? It's pure courtroom theater. The lawyer's voice echoes sharp, relentless, setting up his client as the victim of lies.
Well, the text messages we provide are out of context and misleading to the court. Well, they didn't provide any other messages to clarify that. Where are they? Claims that he's so terrible, yet she's inviting him over to the house on a regular basis to help with things doing this, help with things doing that, to help with their daughter. I just think these allegations should ring hollow with this court. Now, if we're willing to agree to a provision in a temporary order that's mutual, that neither party will consume alcohol 12 hours prior or during parenting time. We don't think this case warrants such a drastic and frankly expensive involvement of SoberLink, which I know this court is aware of. That's an extreme measure to use in extreme circumstances, which we don't have here. But if the court is inclined to order the same, obviously we will comply with that, but we would ask that it be 1, mutual, 2, she pay for it, 3, that it be only for a short duration, and also ask that the court would look at alternatives to that. I have recently been apprised of a competing program called Keeper that is significantly less in cost. It's spelled KEEPR.
Now Quinn flips the focus, accusing the mother of mental health instability. He questions her counseling, her medication, her emotional fitness as a parent. The judge listens closely, but the tension is thick. He argues that Mr. Roderick's parenting time is limited unfairly, that he's just trying to see his daughter more regularly. Quinn offers a deal. Both parties avoid alcohol before parenting time, rejecting expensive SoberLink monitoring as unnecessary. His voice drips with sarcasm. Extreme measures for extreme cases, Your Honor, and this isn't one.
Now, I also want to point out that I thought the response sidestepped an issue that is quite important. The plaintiff's mental health, which is documented. We need some assurance that she's seeing her counselor regularly, she's on whatever medications need to be prescribed, or an open flow of information with that respect, because we have concerns about her history of mental health issues. Now, they're in the response, they reference, well, he's no-showed for parenting time. We disagree to that. They reference in the response that he's refused parenting time. Well, I think we can admit that on a couple of occasions, he had to decline some time because he was given notice at the last minute, already had plans that he couldn't move, which is part of the reason why we're requesting a specific schedule in the first place, so he can base his life around it and do what he needs to do to exercise all the time afforded to him. He's not asking for 50-50 parenting time. He's asking for one overnight a week and alternate weekends from Friday to Sunday. Now, the next request in the motion concerns nesting. There have been, or the plaintiff has brought up in the past, that she does not think.
Continues hammering. If you must order alcohol testing, Quinn says, make it mutual and cheaper. He even introduces a low-cost alternative called Keeper, trying to save face and money. Then he shifts gears, pointing out that the plaintiff's mental health shouldn't be ignored. He claims her instability poses more danger than his client's alleged drinking. He insists the father's missed visits were because of last-minute notice, not neglect. The crowd feels the courtroom divide, one side defending love, the other painting danger.
That where Mr. Roderick is residing temporarily is an appropriate place for their daughters to spend even one overnight. We disagree with that. We've attached photos of where he's temporarily residing. It's in a campground where lots of families are. But to eliminate that concern, we propose a nesting, which would be best for their daughter. She stays put. She can sleep in her bed every night. It doesn't require the parties to have any additional interactions. It will ensure that the marital home's kept reasonably clean. And she has a place to go. She has immediate family within only a few miles of that house that we believe she can stay at no cost to her. And minimizes costs for both parties, because Mr. Roderick's going to need to secure a new residence. This is just a temporary arrangement. Last, with respect to finances and support. In support of our motion, we attached pay stubs. We attached an excerpt from the party's historical tax return only a few years ago, with her earning approximately $50,000. We attached both child and spouse support calculations with variations of income. I did note.
All right, guys. Now the defense introduces the nesting plan. Quinn argues that since mom doesn't want the child sleeping at dad's temporary trailer, they can simply switch houses while keeping the child in the family home full-time. It's creative, but risky. The courtroom buzzes. He insists it's cheaper, stable, and keeps the daughter in familiar surroundings. He tries to sound practical, but you can feel desperation behind it. He's fighting not just for time, but for dignity, for the right to still be seen as a father.
In the response, that the FOC is apparently doing an investigation as to child support. I don't really know how that came about. He got some documentation just the other week, and so did my office, that he needed to submit an income questionnaire, which was due last Friday. He did. But I don't know how that came about. So just for the court's information, it is in the works for at least.
Let me just stop you a minute. Ms. Slate, do you know anything about that? I found that odd too.
I don't, Your Honor. I can have my staff call and see if there's another docket sheet, but I don't know why they would have received that. I don't have any paperwork on that.
Okay. All right. Thank you.
We attach as Exhibit L what he received, and it's this case number.
Yeah, I found that odd too. So.
Yeah, that was bizarre. Now, in the response, they report, well, she shouldn't be imputed income because she has this medical issue. We agree she hurt her foot and underwent a lot of stuff, but that was in the past. She has a history now of earning $50,000 a year.
Now Quinn shifts to money, and it gets fiery. He claims his client provided pay stubs, tax returns, everything transparent. But the plaintiff, he says, hides behind injury excuses to avoid working. He calls for imputed income, arguing she's capable of earning $50,000 a year. She's been to Florida recently, he points out, so clearly she's fine. The judge listens, arms crossed. Quinn's tone sharpens. It's not fair my client shoulders all expenses while she sits idle. The courtroom grows cold. It's pure financial warfare now.
It wasn't a construction job where she's doing strenuous manual labor from sunrise to sunset. She's interviewing now. I believe she had an interview just the other week. She just traveled to Florida without any issue, from our understanding. She regularly drives. She claims she has work restrictions still, but none of those are listed in the response. We don't know what, if any of those actually are, or if they are self-imposed or doctor ordered. Now, we think the court needs to impute some income to her. It needs to give her some incentive to work and not have Mr. Roderick shoulder all of her expenses, all of his expenses, and shell out support to her. Now, the response also proposes that the parties simply divide all income. We attach the pay stubs. That would account to her getting north of $4,600 a month. That is way higher than what our support calculations show to this court, and gives her a considerable windfall, puts Mr. Roderick in a financial bind where he can't secure new living arrangements or really do anything to get himself on his feet and get a more long-term arrangement in place. It's way more than her expenses. Now, as detailed,
Quinn accuses the mother of exaggerating expenses to drain his client. He says her proposal gives her over $4,600 a month, a windfall, he calls it. He argues Mr. Roderick still pays her bills directly, keeping her comfortable while struggling himself. He's not refusing to help, Quinn says. He's cutting out the middleman. You can feel the emotional exhaustion in his tone, part logic, part frustration. The tension builds like a pressure cooker. Everyone's waiting for the judge to speak, but first the opposing attorney steps in.
In the motion, he's willing to continue to pay certain expenses on her behalf. We've detailed those in the approximate amounts in our motion, which equates to pretty much what his support obligation would be under the calculations. And rather than shell out money to her, where she needs to turn around and pay these various expenses, which his name is on, he just rather cut her out of the middleman and pay those expenses directly to ensure that they are being paid, especially those in his name. Now, I don't have any other things to add unless the court has any specific questions of me.
No. Ms. Slate.
Your Honor, I will try and be brief. This motion is 88 pages long. It includes a number of exhibits, and it is just a recitation of statements made by Mr. Roderick. This is classic gaslighting. Ms. Roderick was in a physically and mentally abusive relationship for a very long time. She now has left the abuser. So what happens now to regain the control that Mr. Roderick has to have? Well, we see exactly what gaslighting tells us. He's going to say she's...
Boom, here comes Miss Slate, the plaintiff's attorney. Her tone is cutting. This entire motion, she begins, is classic gaslighting. She calls the father a manipulator, an abuser hiding behind fake logic. She paints a picture of a woman finally free from abuse, now being dragged back into control through paperwork. He tells her to kill herself over a sandwich. She reads from texts. The air shifts. The courtroom freezes. The power dynamic just flipped, and now the defense looks smaller under her relentless fire.
Got mental disease, and try to convince those people around Ms. Roderick that that's true. You'll see in the text messages that Mr. Roderick attaches, Ms. Roderick says that he tells her to go kill herself because she doesn't make him a sandwich. We have a 9-year-old child, a girl, in this situation. Mr. Roderick isn't requesting extensive parenting time because he knows he cannot handle it and he cannot be appropriate. And that has been consistent throughout this relationship. Ms. Roderick has maintained the role of gatekeeper. And what we don't want to have is a 9-year-old girl subject to an abusive father He cannot control his alcohol consumption. In fact, it's increased since the parties separated. 316, his phone location showed him at a bar in Chicago all day when he was supposed to be down there helping his mother. The entire day at a bar. And that just continues. The alcohol consumption, whether or not it's led to an OWI, clearly he calls friends to pick him up when he's been drinking from the one police report we were able to get. This motion was filed late Friday afternoon. And
Slate's voice trembles with controlled anger. She talks about their 9-year-old daughter, describing a father who can't control his temper or his drinking. He's not asking for 50-50, she says, because he knows he can't handle it. Every word hits like a hammer. She demands supervised parenting time, protection for the child, and accuses the father of prioritizing alcohol over family. The narrative turns dark. She's not just arguing law. She's painting survival. The judge listens, quiet but visibly moved by the gravity of her words.
88 pages long. FOIA requests would take us at least 5 days. But they also don't have any evidence of her mental health or bipolar disorder or suicidal ideation. There's no suicidal ideation. He asked her to go kill herself. That's ridiculous. I'm glad Ms. Roderick is taking a step forward to get away from him. We need to protect Charlie. The parenting time that they're requesting should be supervised to start out with. We need to see if Mr. Roderick, for extended periods of time, can act as an appropriate parent. We don't believe that he can. We do not believe that he can refrain from drinking alcohol for that amount of time. He has a relationship with alcohol that supersedes both Ms. Roderick and Charlie. And we need to carefully monitor that. As for the income, the total expenses for Ms. Roderick at the home are $1,828.24. That's the mortgage, house insurance, car insurance, phone, and her student loan. That doesn't include utilities. So she's got to clear $1,828.24.
Now Slate brings receipts. She claims his phone GPS showed him at a bar all day while he was supposed to be helping his mother. He lives in a trailer, pays no rent, but spends on alcohol. She calls out financial abuse, saying he controls groceries and access to money. It's a brutal portrayal of a man using money and guilt to dominate. She insists the child must be shielded, not shared. Every phrase drips with accusation and pain. This is no longer a custody case. It's a war for safety.
Mr. Roderick is living in a friend's trailer and doesn't have any rent payments. So his only expenses are his food and clearly his alcohol, which we'll be getting those bank records and credit card statements. The total household income is $8,418 for the month. I think it makes sense to divide the income. Have Ms. Roderick pay her expenses, and then she can have additional funds for groceries and the like. What he's done, and is classic of abusers, is also engage in financial abuse. Since the separation in March, Ms. Roderick can't have access to money. What he does is, I'll go to the grocery store for you and I'm going to drop off what you're going to eat. Or I'm going to move back into the house. And all of these other abusive tendencies. If he was so concerned about the living conditions of Charlie, or if Ms. Roderick had these mental health concerns, why wasn't he back here in March? Why didn't he rush into the courtroom in March? It's because they're untrue. Absolutely untrue.
She continues tearing down his financial argument. The household income is $8,400, she says, and she's the one paying the mortgage, the insurance, the car. Her voice shakes with fury as she calls his tactics manipulative and abusive. She claims he cuts off funds, controls food, and pretends it's care. The audience feels the gut punch. Her plea is clear: supervised visits only. This isn't about revenge. She frames it as survival, a mother's instinct to protect her daughter from a man she calls dangerous and unstable.
So we would ask the court to provide him with a limited parenting time schedule to start, that schedule be supervised, that he not drink alcohol during his visits, We would ask that the household income be divided for now. And Ms. Roderick would then be responsible for paying the expenses of the place in which she's living. And we'd ask that it be sent to the friend of the court for review on that parenting or the child support, which it looks like it might already be, and I have my staff looking into. And other than that, we're agreeable, like I said, to the joint legal language and also the inherent rights, which is just standard language for a temporary order.
All right, thank you. Well, I will refer this matter to the friend of the court for a review regarding child support, parenting time, and custody. It sounds like the child support's already started, which is, in this case, is good. I will, as far as temporary custody, physical custody, I will grant the plaintiff temporary sole physical custody. I'll grant Mr. Roderick parenting.
All right, guys, here comes the judge's turning point. Calm, firm, but decisive. The judge orders the matter referred to the friend of the court for review child support, custody, and parenting time. But before that, she drops the big decision. Temporary sole physical custody goes to the mother. The father only gets limited visitation Wednesdays 5 to p.m., alternate weekends, and must submit to alcohol monitoring through SoberLink or Keeper. The courtroom goes still. This is the moment that decides everything. Order restored at a price.
Time rather than overnight on Wednesdays on a temporary basis again until we get all of these allegations sorted from 5 p.m. until 8 p.m. Every Wednesday, alternating weekends as proposed by the defendant, which is alternating weekends, Friday after school, if no school, at 5 p.m. until Sunday evening at 5 p.m. That is all subject to participating in either SoberLink or Keeper. I've not heard of that, Mr. Quinn. If it's less expensive and reliable, I have no objection to using that. Ms. Slate, do you have any idea about this Keeper program?
I have not. There's also the backtrack program, so I guess we could look at all three and determine which one meets the needs in terms of alerting Ms. Roderick.
Okay. Yes, I don't. I mean, we're not in the business of trying to enrich these companies that do this. So if you can find a less expensive, reliable option, I'm all for that. I don't want the parties spending money they don't need to spend. I will also grant the plaintiff exclusive use of the marital home. I do not think, given the allegations that are flying back and forth, that a nesting arrangement is appropriate. I think that just exposes this child to even the potential for more tension, which children definitely feel in these situations.
The judge's tone is direct. We're not here to enrich companies, she says, rejecting expensive testing systems. But she makes it clear father must pay the costs. She denies the nesting plan outright, calling it unhealthy and confusing for the child. She needs stability, not tension. Her focus turns to the little girl, reminding everyone that children in conflict often blame themselves. It's a powerful moment. You can feel both parents' hearts drop. The judge's voice cuts through the chaos like steel. This is final authority.
And actually blame themselves often. As far as payment of the bills, the defendant on a temporary basis shall pay all of the bills that he indicated in his motion, as well as a $500 amount to go towards groceries and utilities and other things. And I'm hoping that the plaintiff will be obtaining a job so that that will not be insufficient. And is there anything I've missed?
I have some clarification questions, Your Honor.
Sure.
So the referral to the friend of the court for child support, parenting time, and custody, would legal custody be included in that?
The parties have agreed to legal custody, so no, I don't think that's necessary.
And then you said some alcohol monitoring device. One, is that going to be a mutual?
There's no
I
allegation.
haven't heard any allegations that Ms. Roderick abuses alcohol, so no, it's not mutual, but I will indicate that neither party should be using alcohol during parenting time. And I meant to say this and I didn't, that requirement is for 90 days. That should give us a good baseline.
And who will pay the cost of that?
Mr. Roderick will pay, and that's something that can be worked out. If there should be any shifting, that can be worked out in the final settlement or trial of this case.
He pays the bills identified in the motion plus an additional 500, and we can just classify that as family support.
Pending the child's, I'm hoping that the child support recommendation will come out sooner than later, since it sounds like they've already started it.
Yeah, so, but temporarily 500 family support, that directly to the plaintiff?
Yes, Ms. Slade is nodding her head, so that's, yeah.
Okay, I don't have any other questions.
No questions
Okay.
on my end, Your Honor.
All right, and is there anything further?
No, I'll prepare the order.
All right, thank you.
As the hearing closes, the judge adds final orders. Father pays existing bills plus $500 family support monthly. The alcohol monitoring lasts 90 days, just long enough to test the truth. The mother retains exclusive use of the marital home. Both lawyers nod. The father sits silently, realizing the weight of defeat. The judge ends it cold, "I'll prepare the order." And that's it. Guy's case closed, at least for now. For more courtroom justice moments, don't forget to like, subscribe, and come back for the next showdown.